Hello viewers, I am Professor Sharanjeet, working at the Rajiv Gandhi National University of Law, Punjab. In today's lecture, we are going to discuss the conceptual dimensions of consumer protection law in India. Let's start the lecture with the introduction first. From the barter or exchange system of goods, we have evolved to the current age of consumerism, e-commerce, and online sales platforms. Globalization has further impacted the market dynamics. In the olden times, the rule of caveat emptor, which literally means let the buyer be aware, was popularized worldwide, which emphasized that the consumer is required to be aware while buying the goods to ensure that they are as per his needs, and the liability of the seller was minimal due to this doctrine of caveat emptor. Thus, the buyer could not blame the seller of the goods if the goods failed to fulfill his specific needs. In a way, the rule of caveat emptor protected the producers, manufacturers, and sellers of the goods, as the buyer was supposed to buy at his own risk. With the passage of time, more and more goods started flooding the market in sealed boxes, containers, and packaging, which was very often opaque and largely made it almost impossible for the buyer to examine them before the purchase. Hence, the modern consumer protection laws started germinating and evolving. In the Indian historical context, the traces of consumer rights and protections can be traced to the Vedic times. The concept of dharma ruled, and every aspect of human life was seen from the perspective of dharma. The Vedas, Manusmriti, Narada Simriti, Yajanvalika have certain references to weights and measures. As per the Muslim law in the Holy Quran, the use of unjust weights and measures has been condemned. After the advent of British rule in India, the law of torts and contract law were applied to protect the interests of the consumers. In the substantive criminal law, the Indian Penal Code of 1860, a specific chapter on offences relating to weights and measures was also introduced for the protection of consumer rights, and certain provisions with regard to the adulteration of food or drink were also incorporated. The Britishers also enacted the Drugs and Cosmetics Act 1940, which played an important role in the regulation of the import, manufacture, distribution, and sale of adulterated or misleading drugs and cosmetics. The Consumer Protection Act 1986, the first legislative framework dealing with consumer rights, was enacted in 1986. However, prior to this law, certain aspects revolving around consumer protection were taken up by different legislations, both pre-colonial and post-colonial, like the Contract Act 1872, the Indian Penal Code 1860, the Sales of Goods Act 1930, the Dangerous Drugs Act 1930, the Drugs and Cosmetics Act 1940, the Banking Regulation Act 1949, the Industrial Development and Regulation Act 1951, the Prevention of Food Adulteration Act 1954, the Essential Commodities Act 1955, the Indian Standard Institution Certification of Marks Act 1956, the Monopolies and Restrictive Trade Practices Act 1969, the Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980 replaced the Essential Commodities Act 1955. It is noteworthy that in the year 1984, the Sachar Committee gave a report emphasizing the protection of consumers in India. the committee observed that with regards to the means of advertisement affecting the consumer choice, the objection is not to the advertisement of the products, which it may be necessary to do in order to acquaint the public with articles. What is, however, insisted on is that there is an obligation on the seller, namely that if he advertises, he must speak the truth. This application also requires that the representation that is made to the consumers must not only contain an element of truth, but must also avoid half-truths to give a deliberately different impression than the actual fact. Thus, the advertisement may be misleading because certain things are omitted that should be said, or because advertisements are confusing or purposefully printed in such a way as to mislead the consumers. In 1986, the Consumer Protection Act was enacted to redress the consumer grievances when the goods purchased were later found to be defective or the services provided were deficient in some way or the other, in breach of the contractual terms and conditions. Hence, the application of the Act of 1986 extended to the defective goods and deficient services. Interestingly, this law was modelled on the UN General Assembly Resolution number 39 of 248 dated 9th April 1985. The basic rationale behind this law was to provide a speedy, simple and low-cost redressal of the consumer grievances in our country. Dear listeners, at the outset, we need to understand as to who is a consumer. The Consumer Protection Act 2019 has defined the term consumer as: consumer means any person who buys any goods for consideration that has been paid or promised, or partly paid and partly promised, or under any system of deferred payment, and includes any user of such goods other than the person who buys such goods for consideration paid or promised, or partly paid or partly promised, or under any system of deferred payment, when such use is made with the approval of such person, but does not include a person who obtains such goods for resale or for any commercial purpose, or hires or avails of any service for consideration that has been paid or promised, or partly paid and partly promised, or under any system of deferred payment, and includes any beneficiary of such service other than the person who hires or avails of the services for consideration paid or promised, or partly paid and partly promised, or under any system of deferred payment, when such services are availed of with the approval of the first mentioned person, but does not include personal appeals of such service for any commercial purpose. Why is consumer protection important? The markets exist only due to the consumers. Hence, consumer protection is of utmost importance. Under the Act of 2019, consumer rights include: firstly, the right to be protected against the marketing of goods, products, or services that are hazardous to life and property. Secondly, the right to be informed about the quality, quantity, potency, purity, standard, and price of goods, products, or services, as the case may be, so as to protect the consumer against unfair trade practices. Thirdly, the right to be issued, whenever possible, access to a variety of goods, products, or services at competitive prices. Fourthly, the right to be heard and to be assured that consumer interests will receive due consideration at appropriate forum. Fifthly, the right to seek redressal against unfair trade practices or restrictive trade practices or exploitation of consumers. And lastly, the right to consumer awareness. Dear listeners, now we shall talk about some important cases. In the case of S.K. Abdul Sarkar versus State of Odisha, the Supreme Court held that through the enactment of this statute, an attempt has been made by the Indian Parliament to provide a speedy and cheap remedy by way of an alternative to the time-consuming and expensive process of civil litigation. In the landmark case of Lucknow Development Authority versus M.K. Gupta, 1993, the Supreme Court explained the philosophy of this social welfare legislation in the following words. In fact, the law of consumer protection means the long-felt necessity of protecting the common man from such wrongs for which the remedy under ordinary law for various reasons has become illusionary. The importance of the Act lies in promoting the welfare of the society by enabling the consumers to participate directly in the market economy. It attempts to remove the helplessness of a consumer which he faces against powerful businesses described as a network of rackets or a society in which producers have secured powers to rob the rest and the might of public bodies, which are degenerating into storehouses of inaction with papers that do not move from one desk to another as a matter of duty and responsibility, and for extraneous considerations, leaving the common man helpless, bewildered, and shocked. In the case of Gulab Hoth Chand Bhagya Chandani versus Egypt Airlines and others, it was observed that the Consumer Protection Act is not applicable in cases involving the course of action arising out of India. In the case of Meera Industries Havda versus Modern Constructions Havda, it was held that in so far as the purchase of goods which is covered by this law is concerned, a person who purchases goods for commercial purposes is not a consumer within the meaning of the Act. If the goods are bought for the purpose of resale, then the buyer of such goods cannot be said to be a consumer under this Act. The Consumer Protection Act 1986 has been amended from time to time in order to make it more robust and receptive to the needs of the consumers. In the year 2019, the Parliament enacted a new Consumer Protection Act with the objective of providing protection of the interests of the consumers and for that purpose establishing authorities for timely and effective administration and settlement of the consumer disputes and for matters connected therewith or incidental thereto. Here it is important to note that the Act of 2019 has widened the scope of the definition of consumer to also include persons who buy or avail themselves of the goods or services through the online medium or electronic means. The new law also envisages mediation cells, allowing parties to attempt to resolve disputes through this alternative dispute redressal mechanism before initiating formal legal action. Mediation is introduced with the view of more speedy redressal of consumer grievances. Furthermore, the Act of 2019 introduced an important change by empowering the State Commission and the National Commission to declare a contract null and void if it is deemed unfair to the consumers. This encourages fair business practices and the prevention of exploitative conditions. Under the 1986 Act, complaints could be filed in a consumer court where the seller's office was located. In the Act of 2019, the complaint can be filed in a consumer court where the complainant resides or works. The composition of the State Commission has also been expanded in the 2019 law. The State Commission had one president and 2 other members as per the old law, whereas as per the 2019 Act, the composition is 1 president and 4 other members. There is also a direct shift from the doctrine of caveat emptor to caveat venditor, let the seller be aware, as the provision for product liability has also been included. Product liability means the responsibility of a product manufacturer or product seller of any product or service to compensate for any harm caused to the consumer by such a defective product manufactured and sold or by deficiency in services relating thereto. Punishments have also been introduced. For instance, Section 89 deals with punishment for false or misleading advertisements, and Section 91 provides punishment for producing goods for sale or storing, selling, distributing or importing goods that contain adulterants. Punishment for manufacturing or storing, selling, distributing or importing spurious goods under Section 91 has been provided. The law also deals with the concept of deficiency of services. Under Section 2, subsection 11 of the law, deficiency means any fault, imperfection, shortcomings or inadequacy in the quality, nature and manner of performance that is required to be maintained by or under any law or undertaking to be performed by a person under contract or otherwise in relation to any service. It includes an act of negligence or omission or commission by such a person which causes loss or injury to the consumers. Deliberate withholding of relevant information by such person from the consumer. The e-commerce rules under the Consumer Protection Act 2019 provide for specific rules and guidelines for e-commerce platforms focusing on transparency, accountability and consumer grievance redressal mechanisms. More recently, the Supreme Court in the case of Neena Aneja versus Jaiprakash Associates Limited 2021 has held that proceedings commenced before the enforcement of the Consumer Protection Act 2019 will continue to be heard by the Consumer Forum established under the old Act and will not be transferred in light of the pecuniary limits under the new law. The Supreme Court in C. Venkatachalam versus Ajit Kumar C. Shah 2011 rightly observed that the Consumer Protection Act 1986 is a social welfare legislation, and therefore the provisions of this law are required to be construed in the broadest possible way in favor of the consumer to achieve the objective behind enacting this law. Speaking about the consumer forums under the Consumer Protection Act 1986, the Supreme Court in CCI Chambers Cooperative Housing Society Limited versus Development Credit Bank 2003 held that the forum at various levels has been formulated with the objective of providing speedy justice to the aggrieved consumers. As the traditional courts are already overburdened, the objective of providing separate forums is to prevent an inordinate delay in the disposal of cases dealing with consumer matters. Furthermore, in the case of State of Karnataka versus Vishwa Bharati House Building Cooperative Society 2003, the Supreme Court, while referring to the legislative history of the Consumer Protection Act and the UN General Assembly guidelines in this regard, held that there is no doubt as regards the Parliament's competency to provide for the creation of a forum under the Consumer Protection Act at the district, state, and national levels for the administration of consumer justice. The court emphasized that the Consumer Protection Act is in addition to the provisions of any other law for the time being in force and not in derogation thereof, as is evident from Section 3 of the Act. This aside, the writ remedies under Articles 32, 226 and 227 of the Constitution are also available to the parties aggrieved by the decision of the redressal forum or commission. More recently, in the case of Bar of Indian Lawyers versus D.K. Gandhi, PS National Institute of Communicable Diseases and another, 2024, the Supreme Court firmly established that advocates are not liable for alleged deficiencies in services under the Consumer Protection Act. The Supreme Court examined the Consumer Protection Act 1986 and the Act of 2019 and made the observations that the primary objective of these laws is to protect consumers from exploitation by producers, manufacturers, and traders in the market landscape. The Act does not intend to cover professionals who are different from business or trade entities due to the high level of proficiency and training required in these fields. In Indian Medical Association versus VP Shanta and others, a writ petition was filed by the Indian Medical Association seeking the Supreme Court to declare that the Consumer Protection Act does not apply to the medical profession by highlighting that the medical professionals were covered by a separate code of ethics. The question before the Supreme Court was whether medical practitioners can be regarded as rendering service under the Consumer Protection Act of 1986, and if the medical services are rendered free, then would it be considered under the Act? In this important case, the court held that the district, state, and national consumer forums can summon experts in the field of medicine, examine evidence, and protect the interests of the consumers. The doctors and hospitals who render service without any charge would not fall within the ambit of service. Hence, in the government hospitals, where the services are given free of cost, the consumer protection law would not be applied. In Messrs. Newtech Promoters and Developers Private Limited versus State of Uttar Pradesh and another, the Supreme Court held that to ensure greater accountability towards the consumers and in view of the objective of the Act, the ongoing projects are also brought under the provisions of the Act. Hence, the retrospective application of the RERA Act was confirmed. Section 18 of the RERA Act confers the right upon an allotee to get a refund of the amount deposited with the promoter with interest if the promoter fails to give possession by the date specified. In the end, I would like to conclude, considering the fact that a consumer pays money for the goods or services, it is the contractual obligation of the seller or service provider to give him the desired goods or services. However, due to defective goods or deficient services, the consumer may feel harassed and cheated. The consumer rights encompass the right to be protected from unfair trade practices, the right to be informed about the quality, quantity, purity, and prices of the goods and services, the right to be granted access to a variety of goods and services at a reasonable price, the right to seek timely redressal, and most importantly, the right to consumer awareness. As the consumer pays consideration for purchasing the goods or services, he has the right to get proper products and services as desired and paid for. In a country like India, the lack of awareness about the consumer laws is an area of concern. Unfortunately, the digital marketplace and e-commerce platforms, when misused, may provide a fertile ecosystem for the criminal-minded persons to commit fraud, counterfeit products, and indulge in data privacy issues. The need of the hour is extensive awareness of consumer rights and the best possible legal remedies as per the contemporary times. With this, we come to the end of today's lecture. Thank you very much.